Does a will have to be probated in Texas? When someone passes away, their loved ones are often left navigating complex legal processes. One of the biggest questions that arises is whether a will must be probated in Texas. The answer carries serious implications for how property is distributed, how debts are resolved, and whether the wishes of the deceased are honored. In Texas, the probate process ensures that a person's assets are legally and correctly distributed. Without going through probate, a will cannot be enforced, and the estate may be handled under intestacy laws, which may not reflect the deceased's intentions. That's why understanding the role of probate is so important, especially when planning or managing an estate. Legal requirements for probating a will in Texas. Under Texas law, a will must be probated to take legal effect. This means it must go through a court process that validates the will and appoints an executor. Without this process, assets cannot be legally transferred according to the will's terms. The law requires that the will be submitted to probate within 4 years of the person's death. If it's not, the estate may be treated as if there was no will at all. Probate serves several purposes. It provides a formal way to pay debts and taxes, resolve disputes, and ensure that all beneficiaries are identified and receive what is due. The court oversees this process to make sure the estate is administered lawfully. If there's no will, Texas intestacy laws guide how property is divided, which may leave out intended heirs or create conflict. Does a will have to be probated in Texas? Yes, it does, if the deceased owned property that requires legal title transfer. Assets like real estate, vehicles, and bank accounts often need probate to be transferred to beneficiaries. However, some assets, such as life insurance or retirement accounts with named beneficiaries, may bypass probate. If a will is not probated, it can lead to several issues. Property may not legally transfer, creditors may not be paid, and the estate may remain unsettled. In fact, if someone holds a will and fails to submit it to the court, others, like heirs or creditors, can petition the court to compel its production. Missing the 4-year deadline requires the person filing the will to justify the delay to the court. If not accepted, the estate might be handled as if there was no will, distributing property according to state law rather than the deceased's wishes. Understanding the probate process in Texas. The process begins when an application for probate is filed with the local county court. A notice is published to alert creditors and interested parties. After a 2-week waiting period, a hearing is held. If the will is deemed valid, the court appoints the executor named in the will, or an administrator if there is no will. That person must then compile and submit an inventory of the estate's assets and debts. Creditors are notified and given an opportunity to make claims. If there's no will, the court may conduct an heirship proceeding to determine legal beneficiaries. Once debts and disputes are resolved, assets are distributed. This process can take 6 months or more, and the costs range widely, from $3,000 to over $10,000 depending on complexity and whether the will is contested. Some assets and situations allow alternatives to full probate. Texas recognizes small estate affidavits for estates under $75,000, and muniment of title procedures for estates with only real property and no debts. Independent administration is another option when all heirs agree or if the will permits it, allowing the executor to act with less court oversight. Avoiding probate is possible in some cases, but skipping it entirely can result in title issues, unresolved debts, and unintended consequences for heirs. It's wise to consult an attorney before deciding how to proceed. If you're navigating estate issues or uncertain whether probate is necessary, guidance from an experienced attorney is essential. The law office of Whitney L. Thompson, PLLC, has helped many families in Houston handle these legal matters with care and clarity. Reach out to our law firm at 281-214-0173 or visit us at 4201 Farm to Market 1960 Road W Suite 360, Box number 116B, Houston, Texas, 77068 to schedule a consultation and get the support you need.